With the Law Society of Nunavut. We have a series of continuing legal education offerings, and if this is your first time viewing one, I'd encourage you to look on our website. We have recorded CLE offerings from the past, and we also have more offerings coming up. My name is Rebecca Jaromko-Bromwich, and I work with the Law Society of Nunavut, helping to collaborate on the CLE, and I have a particular interest in equity, diversity, and inclusion. And I'm very happy to welcome with me today Alicia Chohan, who is a lawyer with the Bar of Ontario, who has worked with a number of Indigenous serving organizations, including Paktutit. And so today we're going to be providing an update on equity, diversity, and inclusion for 2025. So just by way of context, and many of you may be very familiar with this, and some of you perhaps less so, but as we all know, Nunavut is an Inuit territory, and the current population of Nunavut, however, is composed of various communities. So 85% Inuit, and also immigrant and settler populations from all over the world live in Nunavut. There is increasing Inuit representation in government and corporate leadership, but that continues to be an issue that the government is working to address. It is one of our roles with the Law Society of Nunavut, and one of our continuing legal education policy pieces is that it is mandatory to pursue continuing legal education dealing with cultural issues and cultural awareness, and providing culturally relevant education and workplace training is important in all businesses and sectors in the public sector as well across Nunavut. And it's important also to ensure accessibility to equitable employment and career growth opportunities in a way that is equitable for Inuit, for settler, for immigrant populations. And it's also important to address language barriers and incorporate Inuit cultural and social value principles. It is significant to note, and one of the reasons we're doing this is because current geopolitical tensions, regardless of what any leader of any other country, whether it's the United States or anywhere else, says, equity and diversity and inclusion and Canadian human rights law are not altered by any policy changes that are made south of the border. And even if this session would be illegal in the United States, we are still continuing on our path in Nunavut, as well as the rest of Canada, with respect to working towards equity, diversity, and inclusion in our society and in our professional sectors, such as the practice of law. So I will turn it over to Alicia now.
Yeah, so thanks, Rebecca, for the introduction. So before we dive further into the EDI presentation, I just want to discuss some terms which we'll be referencing and are really going to set the foundation and describe identities that coexist within Canada. So I'm going to start off with the first definition, which is displayed, which is the settler colonial experience. So this is the Canadian identity, and this is the identity of the majority experience. And from a legal sense, this experience forms legislation, it operates and shapes the interpretation of current laws and the judicial system. So now the difference really comes in with the immigrant experience. And this experience is unique and is dependent on where you're coming from jurisdictionally, and also how many generations your family has been part of the settler identity. So for example, someone coming in from Europe may have a much easier time fitting in culturally than someone from Northern Africa, or even vice versa, as each experience is unique. And so the immigrant experience is also impacted with where in Canada you settle. If you're living in a larger hub versus a smaller city, this dictates the degree of mainstream settler, colonial, and Canadian assimilation you will have. And then there's an added layer to it, which comes in from being a refugee or even an asylum seeker. And this is a form of immigration that's not by choice. And it could be due to war or other threats against personal safety. People who are refugees and asylum seekers are really impacted as their diverse experience matters, as this population often carries a lot of stigma and personal burden. And lastly, I want to touch on the Indigenous experience. So Indigenous peoples are the original settlers of the land, yet are forced to live like the outcast population. Settler colonial legislation and culture is ingrained in the honor of the crown. Norms, identities, policies directly still marginalize Indigenous peoples and render their experience as a part of ongoing colonial cycle to further abolish their identity. And it's important for us to reflect on the uniqueness of the Indigenous experience and understand how it is rooted in years of intergenerational trauma. And so with that, I want to give it back to Rebecca for the next slide.
Thank you, Alicia. So when we're talking about equity, diversity, and inclusion, this will be a review for most people, but just so that we're clear about what we're talking about. People see ways that we are different from one another. So we perceive visible characteristics of a person that make them different or make them appear the same. Things like our age, things like our gender and gender expression. These are things we perceive within a fraction of a second. Our physical ability, our race and ethnicity. These are things that we perceive as soon as we interact with someone immediately. But there's a lot that's complicated and even tricky about people's identity. So human diversity is a fact, but what that actually means and how that signifies and how that impacts our lives is complicated. And there are a lot of underlying characteristics about us that make up our personality, our social identity, our social location that are below the surface and might not be obvious immediately. So for example, our gender identity may not necessarily coincide with our gender presentation. Our education level may not be obvious. Our sexual orientation may not be obvious. In fact, it's invisible. There's no reason it would necessarily show. Our marital status, our life experience, our talents, our many non-visible disabilities that people don't necessarily show. So human diversity is complicated. And we can be biased in ways that are subconscious. We can be biased against one another in that perception, in that fraction of a second. We can make snap judgments about people that can result in tangible and significant consequences. We might pay less attention to someone. We might address a person less respectfully. And these our perception of people's diversity can lead to cumulative disadvantage. So it doesn't have to be overt and intentional racism that can lead to disadvantage based on bias. Moving on to Alicia.
Yeah, so Rebecca shared some really interesting points that we often play out in the bias that we unconsciously have. And I just want to tie it in to how it actively pays out in life. So from a personal perspective, I was not born in Canada, and my family immigrated here over 2 decades ago when I was in grade 2 and my younger sibling was in kindergarten. So Ottawa, over 24 years ago when my family first moved, and if we do the math, I've aged myself, but it was predominantly Canadian with very little diversity. And my parents, despite being professionals of people who were a doctor and an accountant from our home country in India, had to work really, really hard to reestablish themselves in a professional setting in Canada once again and build a brand new foundation for our family. And so this task of rebuilding as an immigrant family in a brand new country that isn't necessarily our own and is our new home was not an overnight job. You know, it was over a decade of hard work, of struggle, and of things of overcoming challenges. And this time period for myself personally and my family, I would consider a lot of, missed years, as we didn't really get to experience a lot of milestones that are part of the Canadian culture and the Canadian identity. And this is the story and the experience of many, many immigrant children and families who do come to Canada. And this experience in itself emphasized for me and my family early on how important work ethic is and how important it is to stand out and work really hard because you're not Canadian. And so you need to work even a lot more harder just to get the seat at a table in equality. And this is exactly why we need equity, diversity, and inclusion practices, because people should not be denied opportunities, mentorship, networking links, job opportunities based upon what they look like and based upon the fact that they may look different from you. They may speak a different language from you or have an accent, and this should not be a factor in denying them opportunities for bettering their lives or just being part of the Canadian identity. And it's important to recognize that as valid as the Canadian identity is, we still need to respect and see it as a changing framework. What Canada looks like and what it looked like when my family and I first moved here is drastically different than what it looks like now, with the influx of immigration, with different newcomers, with different populations in the regions. And it's important to allow these opportunities and to have people create a new Canadian identity that is built off of collectiveness. And so it's really important to understand people from not just what they look like, but also their lived experience. And with that, if you have an added layer of someone who is an asylum seeker or a refugee, it becomes even more drastic to be mindful of how unique they are as an individual and how their trauma can play a factor in them fitting in. So people who are refugees and coming from an asylum seeking population are often coming from war-torn areas or have lost families, have been through genocide, and their trauma and their lived experience is drastically different than what the Canadian identity is. So it's important to know as a lawyer and as a professional what the client is and what their background is and who the person you're speaking to. You know, we have overt biases based upon what the individual may look like, but there's a whole story and a whole narrative of them and who they are as an individual that, you know, really shapes and will have a large part to play in how they handle the legal system and how they handle being part of, you know, the outcome that they're seeking. So discrimination from a legal standpoint, and discrimination from how it plays out to be from an interpersonal standpoint is drastically different. And as lawyers, it is important to understand our client's perspective matter, and specifically with the immigrant and refugee communities who may have language barriers, may have other things that have come up in their lives that do prevent them from being fully immersed in the Canadian identity. And so, you know, things in order to incorporate, in order to make it a safe place for immigrant and refugee communities who are in the legal system could be just as simple as being accommodating. You know, many immigrants are working multiple jobs or have language barriers, and just taking the time to just repeat something again or just say it in a more laid term will really help them feel that they're being understood and acknowledged. Additionally, it could also be something super simple, like working around their schedules, you know, and working around their own child rearing practices, respecting gender roles. And all of these factors really play into ensuring that as professionals, we're really abiding by how we can push forward the equity and diversity agenda in a workplace setting. So with that, I'm going to turn it back to Rebecca.
Great, thanks, Alicia. So why work on equity, diversity, and inclusion? Well, Alicia's certainly given us some good reasons with respect to immigrant population. As a Canadian lawyer and Canadian citizen, as a member of the bar, it's the right thing to do. It's part of what is set out in our ethical code in Nunavut as well as in other jurisdictions. It's also beneficial if people feel included, if they are meaningfully included, if there is an equitable opportunity for advancement, they are more likely to stay with an organization. And also diversity brings a value in different perspectives. So when people don't have as homogenous a work team, they actually are going to come up with better solutions. And there's lots of statistical evidence demonstrating that diverse teams come up with better solutions. They might take longer sometimes to come up with a solution, and they might have more debate within it because when people are different, they might take longer having a conversation about things, but ultimately there's a value add from that. So diversity, as we said, is a human fact. People have lots of traits that we're born with, traits that we acquire from experience, such as where we have grown up, our culture. Those are acquired factors. We also have the concept of inclusion. So this idea that Alicia has referred to specifically with reference to immigrant populations, creating an environment where people feel involved, respected, and connected. And there's lots of little ways that we can, in our own lives and our own professional work, do that. And then there's also big systemic ways at the macro level where we can work towards inclusion. And these all result in improved business performance. We will do well by doing good. So it is a good news story with respect to equity, diversity, inclusion. It actually leads businesses to do better. It leads law firms to do better. It leads us to serve our clients better. So just talking about, as Alicia said, there were some, go-tos with respect to our own individual lives and we're going to talk later about macro level solutions, macro level efforts to advance the EDI agenda. But on the personal, there are some ways we can address forms of bias. So if you look at the slide and you look at the pattern, what's actually there are a series of blue boxes. But if you look at that for 30 seconds and then you look up at a wall or look at something that is light colored, you will see a different pattern because your eyes are actually going to, through your cognition and through your perception of your visual field, you're going to see things differently than they are. And so you will see a configuration of lines. And in fact, there aren't lines, but the way that that's displayed produces a perceptual confusion on the part of us cognitively. And I just highlight that just to remind everybody that our experience with the world is mediated by our perception, and our perception is mediated by the facts and the realities of human cognition. So this is all relevant to how we interact with each other with respect to equity, diversity, and inclusion. And this is a demonstration of how. So if you look at these three different people, one of these people is an engineer, one's a professional athlete, and one's a CEO. And if you look at them, you don't actually have enough information to know who is who. This doesn't provide enough information to know who is who. But in your mind, you might have guesses. And the guesses can only be based on assumptions. So if you have a guess about who is who, those guesses can only be based on assumptions. We do not have the information required. So we're acting on inadequate information, which actually happens in the world a lot of the time. And so I don't know if your guesses were correct or not, but maybe not. So stereotypically, the middle-aged white man actually was the athlete. And so that might be counterintuitive to mainstream stereotypes about what athletes look like. He's a competitor at the Invictus Games, and he is using a wheelchair as well, which again flies in the face of assumptions we might have about athletes. Tira Gwynn is an engineer, and Nahal Manhani is a CEO. So maybe you got those all right, and that would be, very clever of you, and I'd be interested in what assumptions you were working from. But generally speaking, the idea that we think we know is based on stereotypical assumptions and cultural biases. And one of the things I think is interesting about this is prior to Hidden Figures, the movie coming out, I don't know if anybody saw it, it was about 5 to 7 years ago now. Prior to that, when I used this, just about nobody guessed that Tara Gwynn was an engineer. But after the movie Hidden Figures came out, more people guessed that. And it just is an example of how we work with assumptions, but representation matters to those assumptions. So if we have an experience of people who look differently, people who are not stereotypically white or male or middle-aged, being in leadership roles, that can influence our perception of who can actually hold those roles and who can do those things competently. So one of the things that's important, for example, in the context of Nunavut, is the idea having role models visibly in positions of authority who are Indigenous or who are from immigrant populations who are non-European can be really important to, for example, children's perceptions growing up, to the perceptions of other people in terms of who can hold those roles. So unconscious bias is going to impact our assumptions about who people are and what they're capable of. They're mental shortcuts. They influence decisions and behaviors. And those unconscious or implicit biases and assumptions impact our ability to be inclusive. So with humility, if we accept that when we are functioning in the world, part of our cognitive processing is subconscious processing, it's intuitive processing, and it's important for us to be aware of that possibility and to provide systems and structures that allow us to mitigate that bias. So the cognitive science behind this, and I'm not a cognitive scientist, but I think it's fascinating. There are essentially two processing systems in the brain, and we're all very aware of them because right now we all have heartbeats and we all are breathing and we all are sitting or standing in a particular space. And much of what our minds are doing is not conscious. And that's true for a lot of processes. So if you can think about times you maybe have taken transit home from work, or you've driven home from work and you're not really aware of getting home, or if you've accidentally taken a turn, if you're going somewhere and you accidentally turn towards your office or towards where you normally go to work, that's because there's a lot of subconscious processing happening. And that's why we practice things like music or sports, is we move conscious processing into the subconscious. So things we've repeated multiple times actually become unconscious or subconscious processing, and they're no longer in our rational, conscious, intentional processing system. And that's not necessarily bad. In fact, it's really important. It's why people who've practiced playing piano are better than people who are trying to play piano for the first time. It's why you're able to read as easily as you can. It's why experienced drivers are better drivers and safer drivers than inexperienced drivers. So intuitive processing isn't bad, but in our intuitive processing, we've also included aspects of our culture, and we need to sort of reprogram that. We need to infuse it, for example, in Nunavut, with Inuit social and cultural values. If, like me, you are from a European settler population, you've grown up with certain set of cultural beliefs, it's important in coming to a space like Nunavut that is Inuit territory that we start looking critically and becoming aware of some of our assumptions, so that we're able to think and process and act in ways that are free from problematic bias. So different kinds of bias that we all have. For example, social bias. We like to affiliate with people that we think are similar to us. That's a human truth. And so when we network, we try to find common ground. And so on the one hand, that's positive, that enables us to find those who are like-minded. On the other hand, if we perceive people to be different, then we might, for example, not hire people who don't seem familiar to us. And then that can be problematic because we're not producing diverse teams. So social bias is one form of bias that's normal for human beings to have, but it's something we need to work to ameliorate or work to address. Information bias, and this is one I mentioned at the beginning, the idea of the geopolitical climate in which we find ourselves. We find ourselves in a world of silos and echo chambers. And this is how this is created. Cognitively, we are better at learning what we already know. We are more receptive to information that accords with what we already think. If ideas are challenging for us, they're actually harder for us to hear. We will pay less attention to things that we don't agree with. There's a natural tendency, there's a comfort level in attending to what we agree with. So deliberately seeking out information that is outside of our normal network is really important for us to challenge our assumptions. And to grow, we have to do uncomfortable things. And then this one, you will thank me for, the idea of capacity bias. We tend to function better. We tend to have less bias. We tend to be more rational in our cognition, and we tend to act more fairly. And there are studies about this with respect to judging, for example, that judges, the question was, and this is a few years ago, it was before AI advanced as much as it has, but with respect to decisions about predicting risk of reoffending, the question was, are judges better, or is a computer algorithm better? And it turned out the human judges were better, except for just before lunch or just at the end of the day. So if they're tired or hungry, they're not at processing as well. And so our functionality isn't as good. And the thing is, as lawyers, we often will be working at capacity. We'll often be very, very busy and struggling to, reach to the edges of all the work we have to do. So making time for decisions and really allocating the time to set up processes in which we make decisions is important to enable us to be less biased. So I'll turn this over to Alicia now.
Yeah, so Rebecca shared a lot about the framework of bias and how it really plays out. And I want to tie it into practice with the experiences that I've had and seen it come up. So, often as lawyers, we forget how law is shaping society and also vice versa. And as lawyers, we're often just responsible for a case to a specific point or a specific point of decision. And we don't really see the depth of the picture and the larger societal implications it may have. So in order to just look at this broader picture, I want to highlight a few things that have opened my eyes and that I recognize how important equity, diversity, inclusion are. And with that, I just want to share a few examples that I've had from prior roles that I've been in. So as I've mentioned before, and so has Rebecca, current legislation is still operating from a settler colonial standpoint. And so in a prior role that I was in, there was a case that external counsel had carriage of, and it was presented on for a specific tax exemption matter. So this exemption was based off the category of a place of worship. So, places of worship being, places of worship being like churches, mosques, synagogues are granted certain exemptions in the Assessment Act for taxation. And so this specific case was brought by a nonprofit who was a Taoist place of worship, and they were applying for an exemption. And obviously, Taoism, I have never met someone who is an adherent of Taoism, and I'm assuming that may be the case for a lot of us. And so Taoism is not a major religion in Canada. And then the argument brought forward by this party was that current legislation of the Provincial Act that they were addressing is still operating from a Judeo-Christian lens, implying that this act is quite clear in how, churches or synagogues can fit that definition of getting the exemption, but other religions and other places of worship do not have the same leniency. And the problem really arises because Eastern secular religions that are different and minority religions, they can't meet the test easily because we're not familiar with it. And we have our own biases in practice when it comes into play when we're interpreting it. And this is because traditional criteria set by precedents and legislation is built off of a Western approach to religion. So the outcome of this case was unsuccessful for the nonprofit. The Supreme Court denied the leave for motion, but this case really demonstrated for me the start of a conversation of a broader issue that Canada looks really different than it did when this act was written decades ago. And it's important for interpretation of legislation to be fluid with time. And at the same time, it's also important for lawyers to grow and mold with this change so we can efficiently defend clients. And the only way to do that is understand and eliminate our own perceived biases and understand different views that we just don't hold. And this issue also ties in to a broader phenomena that we see and that Rebecca has touched upon, and that demonstrates that a lack of inclusion and implicit bias in the legal workplace. Until judges, lawyers, and the judicial system become aware of things like religion, equity, diversity, different experiences than just their own, we cannot push forward this diversity agenda. And this is exactly why representation really matters, because people who look similar to us and are holding that power may be having a different worldview than what has been the traditional legal status quo, and they can open the door and pivot this change to allow other interpretations to come in. This case also highlighted to me how it's really not fair to pigeonhole novel matters that are unique and different. And it's also not fair to take legislation that's written decades ago and interpret them with precedents that may not be valid anymore. And moving forward, given what this case has represented, it could be that with the change that we see in Canada in diversity, that other religions and other things pop up that do make us reflect upon legislation in a different manner, then maybe have it be open for amendments. So given that, there's another example that I want to share from my previous work with a federal Indigenous group. And this is with a specific case called Daniel versus Canada. And this specific Indigenous group that I worked with represents non-status, off-reserve Métis and the Southern Inuit population. And so the Daniel versus Canada's decision was a 2016 landmark decision in which the Supreme Court held that the federal government has a fiduciary responsibility to legislate on issues related to Métis and non-status Indians. So from a legal perspective, this entity had won this case, but the impact of it really is quite drastic, because winning this case is not just a huge deal on paper, but for this organization, it meant that Indigenous populations who classify as non-status, Southern Inuit and Off-Reserve and Métis, now have a voice and to be fully heard by government entities, which was not adequately the case prior to 2016. So the social repercussion of this case demonstrates that these Indigenous groups and these voices now have a seat at the table and can have dialogues with government partners about the same issues like justice, health, MMIWG matters, and reconciliation. But the perspective that they're bringing in is not just the perspective of a status First Nations or a Inuit that resides under the land claim agreements, or fits into specific distinctions that the Crown had initially put into place. And so these people who are coming in are very unique, and these Indigenous populations have their differences, and eliminating that bias really allows us to see how diverse the populations are in order to best support them. So winning this case, obviously, for this organization went beyond the courtroom, and this work experience demonstrated to me how law is a tool for social reform and how it can directly shape programs and open funding streams for marginalized communities to shape their own future and narrative, and how diverse experiences really matter in practice, but also outside of practice and in the real world in our society. So with that, I'm going to give it back to Rebecca for the next slide.
Great, thank you. So in terms of disrupting bias and creating accountability, we're going to talk about what we can do as professionals at the individual level, at the micro level, the level of micro processes and avoiding microaggressions. And then we're going to also talk about systemic changes and how the Law Society of Nunavut is involved in that. So change takes deliberate effort. The easiest thing to fall into is to act with bias. The easiest thing to do is to be part, essentially, of the problem, to be part of a growing mismatch between the current identity of Canada and the legal regime of the past. So if we accept the susceptibility we have to bias, if we accept that there is inequality in our history, there is a history of colonialism, that we accept the truth, for example, of the TRC report, the Murdered and Missing Indigenous Women's Inquiry report, if we accept those things, then we have to be aware of the possibility of making mistakes, the possibility of acting out of bias, and the problems of colonialism. So we should care about that, and we should dedicate time and effort to mitigate bias and to mitigate the problems that have been in existence with our colonial, legal, and social order. We should expect challenge from others, and we should expect this to be a difficult process. So over time, on the micro level, our biases can accumulate and lead to disadvantage for certain people and advantage for others. That's unfair. And then at the systemic level, it can result in manifest unfairness. So we're turning over to Alicia.
Perfect. Yeah. So with Rebecca's theme about, bias and creating accountability, I want to circle it back and bring it back to indigeneity and some aspects of how we as legal professionals can create accountability from a systemic standpoint. So, historically speaking, the Indigenous experience is very different than the immigrant experience. Immigrants come here, but Indigenous peoples have been here. And it's important to recognize so many factors have shaped the Indigenous identity. The Indian Act, residential school systems, the 60s scoop, reserves have all in a way set up the Indigenous populations and their identity to be, in a way controlled by the Crown, as legislation really dictates who they are as individuals. From my experience, I've seen that there is an imbalance of power. So Indigenous peoples must turn to the Crown for support on so many matters. All programs and fundings for, things like drinking water or any other healthcare settings are all vested in the Crown for Indigenous populations to prove that they're deserving of it, despite being the original occupants of this land. Even simple things, like who has Indigenous status or not, or who gets to be Indigenous under the Crown's perspective, is all in the Crown's decision. from my past, I have previously worked with coworkers who were Indigenous, but were non-status holders. And I found that really interesting. And they had explained to me that under the Indian Act, under legislation, it's if a woman who was Indigenous married a non-Indigenous man, she would lose her status. And that status could not be passed down given the patriarchal agenda of the colonizer population. And that is still playing out intergenerationally. And this individual was telling me that they have lost status because a grandmother married outside, and for them, their existence as an Indigenous person doesn't exist under the crown, despite them being one and identifying as one. And so I think things like identity formation do also create, a bias in the system that we get to dictate who is Indigenous and who isn't. And that in itself is a very unfair process. And another way that systemic concerns impact Indigenous populations that I've seen is also through birthing orders. I've had the chance to work with Paktutit, and I have seen and heard stories about, Indigenous women in reserves or communities that don't have access to hospital or prenatal or even necessity care, and they must travel thousands of kilometers away from their home communities because Indigenous midwifery practices that were traditional to the land have been abolished and no longer exist in many parts of the community. And now the expectation really is through mandates is that women must travel to a hospital in a Western setting in order to get the same type of care that I can or other individuals can in an urban dwelling. And this in itself is something not everyone can afford. And it directly impacts not only the mother and the child, but also families, the economics behind it. And there's so many factors tied in to how this is detrimental to the safety of the women, the children, and the communities. Domestic violence and sexual abuse is also a large issue. In my previous work, I've spoken to individuals who have stated that women in their home communities often don't report abuse, or community members often just brush off extreme matters of sexual abuse because they're so afraid of further crown intervention in their home communities, and they don't want to be part of a government system, and they want their autonomy. And this is detrimental in so many ways, as it adds to the vulnerability of women, their safety, because you have the perpetrator, the victim, and families still coexisting in the same home community, setting other individuals up for unsafety in their place of in their hometown, which is supposed to be a safe environment. All of these have shaped Indigenous peoples and their vulnerabilities, and this is just like the tip of the iceberg. And there's so many factors that have come into play. And so we have to recognize that when Indigenous peoples are entering the legal system, they come in with not just previous years of intergenerational trauma, but also trauma that they're carrying forward that is their own. And it's important as lawyers and legal professionals to be mindful of this trauma and create a space for healthy conversations so we personally can push forward systemic growth in a more positive way. So for Rebecca, we can go to the next slide. Perfect, thank you. And so, given that, I want to shift gears a bit and discuss how Indigenous concerns that have come up are being managed federally. So right now, federally, we are in the era of reconciliation. And the driving force for reconciliation is through a legislation called UNDA, which is the United Nations Declaration on the Rights of Indigenous Peoples. So UNDA received royal assent in 2021, and it is going to be the vehicle that is going to be used to affirm basic human rights for the Indigenous population. So right now, UNDA is at an action plan stage. So there's about 181 measures in it that span diverse fields of socioeconomic, safety, MMIWG matters, justice. And the plan is to keep continuing, dialogues and consultations in collaboration with Indigenous communities to understand how to take this action plan and really pivot it towards, funding and programs in the near future. So right now, the action plan is supposed to run from 2023 to 2028. And as we know, The action plan is really contingent on shifting political matters that do exist, shifting governments, and the relevancy of certain matters being picked up, like justice becoming a predominant force versus health, is really dictated by agenda topics and political mandates that we can't really control. So this is supposed to be an ongoing conversation with Indigenous peoples to formulate a strategy for moving forward. Given the scope of this plan, it's not without its complexity. It is a federal plan. And what I mean by that is that it jurisdictionally can only bind the federal government, and provinces and territories, unless they formally commit to it, are not bound by the action items in the plan. So it really means that matters outside federal scope, like education, civil rights, municipalities, hospitals, cannot really be captured from the federal sphere, which includes funding and also includes programs. Currently, BC and Northwest Territories are the only jurisdiction that have committed to this plan formally to incorporate it within their provincial and territorial government as well, with BC being more advanced in the process and is leading the way for it, and which is what the federal government is really mimicking. So UNDA is here to shape the future of how law is done in Canada with Indigenous peoples, and is going to shift our system. And we need to be adaptable to this shift professionally by understanding and respecting the Indigenous experience. Given that this plan is in the action plan phase at the moment, capacity building and understanding EDI initiatives and how important it is to understand the Indigenous perspective as lawyers is going to be an important foundation that we can create within our own practices for when UNDA formally rolls out in legislation and has acts that really impact the work that we may be doing in certain spheres. So organizations can build capacity by understanding Indigenous voices, but also incorporating Indigenous voices, specifically Inuit in the northern regions, to push forward the commitment that's federally been mandated. The legal profession will be directly impacted by UNDA through the interpretation of laws, the treaties, revitalization of Indigenous order. And the aim is to create an equal system, similar to how civil and common law exist. UNDA really aims to have Indigenous peoples' rights and legal order achieve that status. So how this change will be interpreted is not yet clear, and direction still has to be given from government partners. But the next few years moving forward mean that a lot of consultation with Indigenous peoples will drive and directly impact the legal landscape and our role as lawyers. And so if we can go to the next slide, Rebecca. Thank you. Okay, and so with that, I just want to touch on what is reconciliation and what true reconciliation really means to me. So we have a National Day for Truth and Reconciliation, but this effort and this activity really needs to carry forward for more than just one day. Canadian law has its roots in traditional settler colonial interpretation, and UNDA is supposed to revitalize Indigenous legal order and give Indigenous peoples the basic human rights and traditions, and it's important to be mindful of that. And as someone like myself who is not Indigenous, I really had to understand and reframe my perspective to understand the Indigenous perspective and what they're seeking and what they're looking for. And an example that I want to share that I've seen as an important part of reconciliation really comes from when I've been at some of the government working tables. And so previously in my role, I have been a part of the MMIWG, so Missing and Murdered Women's Working Tables. And in that, you often have representative family members who have had their children or someone that they know murdered or go missing, and they're an important voice on the table. And these conversations with government partners to push forward the MMIW agenda for safety is really hard. They feel discomfort from multiple sides. There's a lot of trauma, and the layer of Crown negotiations added to it and pivoting timelines with political mandates really make it triggering for the Indigenous partners that are involved. And this is when, as a lawyer who's not Indigenous myself, And as many of us who may not be, it's really important for us to step back as a lawyer and really understand what reconciliation and retributive justice really means from an Indigenous standpoint, and not the Western lens and not the own bias that I'm carrying into it. It is to let the Indigenous client and the Indigenous voice really shine and have the space to pivot the change that they wish to see for their communities. You know, being someone who's non-Indigenous, I really consider myself as an intermediary between the two worlds. I'm here to present my version of the expertise that I've gained over the years and lead the conversation as an ally and as a lawyer. But at the same time, I also have to ensure that I'm not overstepping boundaries when working with Indigenous and even immigrant partners, because this work is for their best interest and they need to be the ones dictating it. And that is what reconciliation really means. And it's including people in the conversation. And it's an important and inclusive step that demonstrates that we're going to be operating from a non-biased perspective and are able to honor people's journeys and their different lived experience. A last example that I really want to share that I often saw come up when I was doing work with Indigenous groups is that in justice related work for Indigenous organizations. So oftentimes I found that Indigenous partners were coming into these conversations and they did not have the same set of understanding of simple terms that we have just been using commonly in practice, like separation of power and jurisdictional boundaries. And so when we would come into these conversations with the government partners, oftentimes Indigenous peoples would not understand the difference between the Crown operating from a provincial standpoint versus what the federal Crown can really do. And this really highlighted to me the importance of working with Indigenous partners to really provide a space where they're well equipped with the knowledge and with the expertise of jurisdictional boundaries that do come up, especially when it concerns UNDA. And when they enter these conversations, they can really direct it and lead the way because they know as to where the boundary really is for what the federal Crown can be offering them in terms of this negotiation matter and what the provincial Crown can be offering them. So, working with Crown partners is already challenging and difficult enough for Indigenous partners and communities. So being inclusive in legal practice really means that as professionals, we step up as lawyers when we need to and let people know what certain legalese and certain definitions mean in lay terms, but also step down when the Indigenous experience really needs to shine and let their perspective also lead the way and dictate the conversation for the future that they're envisioning through UNDA. And so with that, I'm just going to ask Rebecca for the next slide. And yeah, so noted here, so I know I've touched a bit on UNDA, but noted here is, some direct calls for justice and direct calls for actions that have come up from the Truth and Reconciliation reports and then the MMIWG report. And these specific calls are demonstrating what the Law Society and what the legal profession can really do in tackling some of the aspects of reconciliation and how we can do our role in pivoting a future forward for these matters. And so with that, I'm going to hand it back to Rebecca to discuss the call for action 27.
Well, I'm sorry, I'm
no worries. Call for action 27.
We had a presentation about this last week that you can see on video. We also have postings about this on our website. There was a consultation last fall conducted by the Federation of Law Societies of Canada, in which I was involved, and so was my colleague Santana. And there was a consultation because the call to action 27 is to the Federation of Law Societies of Canada, and they are called to ensure that there's appropriate cultural competency training provided to lawyers across the country. And in response, the Federation of Law Societies has made proposed changes to its model code with respect to legal ethics. And a lot of input was provided by lawyers from across Nunavut, maybe some of you who are here today. And we provided a report resulting from that consultation that was provided to the Federation of Law Societies of Canada. That report is also available on our website. There will be a follow-up because that was a first round of consultation. The Federation has made its proposals with respect to changing the model code, and then it will subsequently make changes to the model code, and we will be in a position where we are being called upon to change our code to reflect what they're proposing as well. The biggest recommendation that was made by, there were many recommendations made in response to that consultation, but one was to have more meaningful and intentional consultation with Inuit with respect to how these changes should be made. And so we were asking the Federation of Law Societies to consult with Inuit leadership and Inuit organizations with respect to their proposals. And also another concern that was raised was the idea that the implicit subject of this regulation is still a settler European lawyer. It just seems that was a comment that was made by some of our Indigenous lawyers that were consulted. And just to make sure that we are understanding that, in fact, lawyers can be Inuit, lawyers can be Indigenous, and when we are regulating lawyers, we are often, the people who are participating in those systems are not necessarily European settlers, and they may be immigrant populations from other places. They may also be Indigenous and Inuit. And so that's what we're doing with respect to that at the Law Society level. Did you want to talk about Call to Action 28, Alicia?
No, I think
Okay.
so I think these are some of the action items that are available for law societies, and there are things that are being implemented by these bodies.
Yes, absolutely. Okay. So that's at the macro level. Remember, I said we're talking at the macro level and also at the micro level. So at the macro level, those are the policy changes that we're working on now. With respect to what I talked about earlier, with respect to bias, in our personal lives and our professional work, again, we can try to address our behavioral change, our own behavioral change, and the behavioral change of our colleagues by raising awareness, by modifying processes. For example, having specific interview questions when we're doing hiring instead of going by feel, which makes us vulnerable to affinity bias, to provide ourselves more time, take more rest, so we're not as vulnerable to capacity bias, and to reach out beyond our own networks, so we're less vulnerable to information bias. So with respect to some strategies for equity, diversity, and inclusion in Nunavut, again, we are not done working on this as a nation of Canada, as a territory of Nunavut, as a law society in Nunavut, regardless of the geopolitical situation in the world. We are continuing to work towards increasing Inuit representation in government and corporate leadership. Providing culturally relevant education, workplace training. Again, that remains one of the pillars of our CLE policy in the Law Society of Nunavut. Ensuring accessibility to equitable employment and career growth opportunities, and working to address language barriers and incorporating Inuit cultural and social values. So we have talked about bias, and so on the personal level, an outcome from this conversation today is providing you some tools to disrupt your own bias, thinking about how to, talk openly despite, again, the political climate of the international world, about equity, diversity, and inclusion, to be aware of the human and business benefits of inclusive workplace culture. So as a final note, Alicia and I have recently collaborated with some other co-authors. Alicia and I are co-editors of a book about mothers in the legal profession and mothers as impacted by law, those identified as mothers. And you note it's in quotation marks because we're being inclusive of transgender mothers, and we have a chapter about that in this book. And we look specifically at how mothers face unique challenges in employment, how policies impact mothers specifically, and how companies can benefit from gender diverse leadership. So it's not that equity, diversity, and inclusion are all about mothers. In fact, equity, diversity, and inclusion are about the human diversity that we all have, and a variety of different ways we are socially located and socially identified. One that is not necessarily a visible aspect of our diversity is our family status. And so mothers are a group that is underrepresented in the legal profession, has historically been faced with disadvantage in the legal profession. And so this book is about that. And so it's you too can purchase it from Cambridge Scholars Press. Alicia, do you want to say anything about that?
Yeah, no, I just wanted to add that this anthology is unique just because the perspective is international, and we have a good mix of lawyers and academics in it who really contributed. So it's we feel it's a great read. So it's really impactful, and I learned a lot of things when I was reviewing this and editing this version of it with Rebecca. So we can share the link for the title for anyone who's interested.
Okay, great. Well, thank you, everyone. I don't know, we still have a few minutes for questions. We've actually presented a wide range of information, trying to do that 2025 EDI update, talking in the micro and the macro level, trying to talk about policy as well as personal. So there's just been a lot that we've gone through, and you are welcome to watch this again at your leisure on the video if you want to, or you can get in touch with either one of us if you have questions.
Sorry, Rebecca, there's just a comment in the chat by Dominique. So I don't know if they want.
Okay, can you see it? I'm having trouble.
Oh, you
seeing
can't.
it.
Okay, you can't see it. Okay, so
Yeah.
I can see it. I'm not. Okay, so I'm just gonna read it out loud.
Yeah.
So it says my main jurisdiction is BC, and to provide a bit of context, unfortunately, BC's effort to implement its Declaration Act have slowed down significantly due to pushback from the opposition party, which originally voted in favor of the Declaration Act. And now a looming economic crisis due to the likely trade war with USA, it remains to be seen how much progress is made over this term of the NDP government in implementing UNDRIP. So no, that's a really relevant comment, and that's something that I kind of like brought up with the shifting political mandates and topics. So I think what the aim for this presentation really was from our end is to really highlight that we can't always rely on government intervention to push forward reconciliation or the agenda for EDI, given that there's so many shifting priorities. And as legal professionals and people in the sphere, if we tackle our own biases and our own assumptions, we are really pushing forward something from a smaller standpoint, which will really carry out in larger practice as well.
I agree. That's very well said, Alicia. I agree. We are experiencing a situation where at various levels, whether it's nationally or internationally, there is a lot of regime change happening, and there's a lot of openness on the part of governmental actors to back away from previous commitments with respect to reconciliation, with respect to equity, diversity, and inclusion. That doesn't mean that we have to, either personally or organizationally at the Law Society level. So, I mean, we can't really comment on what's happening in BC, but we're trying to continue to advance the agenda with respect to equity, diversity, and inclusion, regardless of what happens at any particular governmental level. Oh, I can see the chat now. It looks like there's more. Okay. I don't think there was another comment there. Okay. Are there any other questions? We are exactly at our time. So thank you so much again, Alicia, for being part of this. And thank you everyone who attended today. Obviously, this is valid for your CLE hours. Please check out our other offerings. And thank you again for your attendance and attention.